So we've just released a bilingual press release on our newsletter. We've got quite a lot to say today and mentioned that press release orally as well. So here goes. So the episode title today is Post-Brexit Regulatory Bias, How the SRA and Law Society Target Cross-Border Solicitors. Welcome to Lawfully Creative, the podcast exploring the intersection of law, creativity and power. I'm Annabelle Gauberti, Solicitor of England and Wales and Avocat à la Cour in Paris. In this special episode, I'm exposing the regulatory abuse and retaliation carried out by the Solicitors Regulation Authority and the Law Society of England and Wales against Crefovi SELAS and myself as a cross-border practitioner after Brexit. So what was the SRA's post-Brexit guidance and dual registration? Let's start with the basics. In July 2021, the SRA Ethics Guidance Team formally confirmed that I could continue to practice cross-border lawfully after Brexit through a dual structure. A freelance solicitor registration authorised by the SRA, allowing me to provide reserved legal services in England and Wales, and a French law firm, Crefovi SELAS, regulated by the Paris Bar, but with a London office. This model wasn't improvised. It was explicitly recommended by the SRA itself in its letter addressed in July 2021 to us at Crefovi and to me in particular, Annabelle. So you can actually download this letter from the SRA at our website's publications, latest publications on crefovi.com in English and on crefovi.fr in French. Number two, the retaliatory conduct. Despite this recent confirmation from mid-2024, the SRA and the Law Society launched an escalating campaign on unlawful acts, misrepresenting my dual registration as misleading, ignoring statutory subject access requests under UK GDPR, publishing defamatory material about me on the public register in breach of their own 2023 decision publication policy, and orchestrating intimidating tactics to obstruct legitimate proceedings. The origin of the abuse, a baseless client complaint. This all traces back to a vexatious complaint from a former client, Kamal Ali, from My Salamat Limited, a UK company and a UK national, about work done in 2023-2024. The Paris Bar had already issued a binding decision in December 2024, clearing me of any misconduct. Yet, in September 2025, the UK Legal Ombudsman reopened the same matter outside its jurisdiction, giving the SRA and Law Society a pretext for retaliation and public threats. Number four, Crefovi's legal action. On 7th of May 2025, I filed claim M01CL921, to be precise, before the Central London County Court. The case invokes breaches of the Data Protection Act 2018 and the UK GDPR, in particular Articles 12 and 15, the Equality Act 2010, the Competition Act 1998, abuse of dominant position, the Defamation Act 2003, and the Protection from Harassment Act 1997. We're seeking injunctive relief to halt further retaliation and force regulatory compliance. Number five, procedural obstruction and medical incapacity. In parallel, I've been recovering from a double fracture of my right arm after major orthopedic surgery at IFCM, the Institut Français de la Main, in Paris. Here's the broken hands, as you can see. Despite certified medical evidence confirming my incapacity to travel, defense solicitors Capsticks LLP and Shoesmith LLP, representing the SRA and Law Society respectively, insisted that the hearing proceeded today on the 11th of November 2025. That insistence violates CPR 1.1 and 39.5 and Article 6 from the European Convention on Human Rights, an example of regulatory harassment through procedural pressure. Number 6, abuse of dominance and competition law implications. The SRA and Law Society's behaviour fits the legal definition of regulatory dominance abuse under Section 18 of the Competition Act 1998, Articles 101 and 102 of the TFEU from the EU competition law, and Articles L421 and L422 of the French Code de Commerce. By restricting reserved legal activities like litigation to UK-established solicitors, they distort competition and block EU-headquartered law firms from fair market access, which is exactly the situation where the SRA and Law Society are trying to put us at Crefovi in. Number 7, regulatory escalation. Crefovi has now filed 4 more complaints with the UK Competition and Markets Authority, the CMA, the European Commission's DG Comp, and the Autorité de la Concurrence in France, as well as notices to the ICO, Information Commissioner Office, and the Parliamentary and Health Service Ombudsman to investigate data protection and administrative breaches. Finally, statement from myself, Annabelle Gauberti. This campaign of coercion and retaliation is unlawful, as set out in Claim M01CL921. It exposes a deep structural bias against cross-border practitioners who built their practice in good faith on the SRA's own post-Brexit guidance. I will not be intimidated into silence or procedural exhaustion. The law applies to regulators as much as to those they regulate. For full details, visit crefovi.com and crefovi.fr to read the official press release and supporting documents. Thank you for listening to Lawfully Creative. Stay tuned and stay lawfully bold.